Hi, everyone. Thank you so much for joining today's webinar. We'll get started in about one more minute, but everybody can get settled. Just some housekeeping things. Everyone should be muted automatically. If you are not muted, please mute yourself. If you do have any questions at any point during the webinar, you can add them into the chat or the Q&A, and we can address them at the end of the webinar. Alrighty, so I guess we can go ahead and get started. Thank you everybody for joining. For those who don't know, my name is Tamalyn Wandler. I am Innovative Benefit Planning's Director of Compliance and General Counsel. This is our quarterly compliance webinar. We have these once a quarter. So if you are not signed up for the other ones for the rest of the year, all of those events can be found on our website. Just a little bit of background on innovative benefit planning. These are some of the organizations that we are a part of. We do all things really on the employee benefit side and HR as well. We handle employee benefits such as health plan, ancillary benefits. We assist with retirement plan and fiduciary executive benefits. We also do HR consulting as well as wellness plan consulting. Here's just a little bit more about us. There's a lot of information on the slide and won't spend too much time here, just in the interest of time for the webinar itself. But just some information. We've been around for over 30 years. We are also a part of the United Benefit Advisors. This gives us access to a national network of other partner firms, of other benefit brokers, which really allows us to kind of tap into everything that is happening from an employee benefits perspective across the entire country. It also gives us access to additional compliance resources, which is something I really benefit from, as well as just allowing us to bounce ideas off of different brokerages and really make sure that we are able to provide the best services for our clients. So with that, I will jump into a little bit about our agenda. I'm going to turn my camera off for the presentation just so it's not distracting, but then I will come back on at the end of the presentation for our Q&A. So again, here's our agenda. I won't really spend time here, but just kind of giving you an idea of some of the things that we will be touching on. So the first item is the Consolidated Appropriations Act of 2021. If you have listened to any of our presentations in the past, or if you were one of our clients, you know that I talk a lot about this. Even though it's from 2021, it is still something that has lasting impacts on plan sponsors. So I won't spend too much time here just because it is something that I talk about consistently. But of course, if you do have any questions on any of these things, if you aren't aware of any of these things, you feel free to reach out. You can throw them into the chat or the Q&A. Also, I'm available to talk about it at any point after the presentation as well. But just at a high level, so the Consolidated Appropriations Act of 2021 established additional requirements for plan sponsors and their fiduciary duty. So specifically, there are four main aspects of this legislation, or known as four pillars. If you, that's what we refer to it as. It just, you don't necessarily need to know it that way. But anyway, the broker and consultant compensation disclosure, the gag clause prohibition attestation, RxDC reporting, and the non-quantitative treatment limitations analysis under the Mental Health Parity and Addiction Equity Acts. There's a lot of words. Again, I'm just going to touch on these things. So the first thing is the broker and consultant compensation disclosure. So what this says is that brokers and consultants that are making or targeting to make over $1,000 in commission on the contract with the plan sponsor are obligated to disclose their direct and indirect compensation to the plan sponsor on an annual basis. Additionally, if there are any changes throughout the year, they also have to send additional disclosures within a certain time period. This mirrors it's almost identical to what we saw on the retirement plan side. So as you may be aware, the health and welfare plan obligations typically follow what is being done on the retirement side, just very slowly. So the retirement plans, for lack of better terms, are kind of the guinea pig for a lot of these things, and then the health plan follows shortly after. So you may be familiar with these disclosures. At this point, you should be receiving these from your consultants and your brokers. If you aren't, that is definitely something you want to look into, want to make sure that you are receiving these. While this is an obligation for your consultant, for your broker to send these to you, still as a plan sponsor, you have the obligation to review these for reasonableness. You want to make sure that these disclosures make sense based on your understanding of the relationship with the parties. Is there compensation there? Is there commissions there that you're not really clear on? Where is this coming from? And the goal of really all of these obligations here is transparency, recognizing that healthcare in general is very expensive for plan sponsors and very expensive for plan participants. So the goal is to really show the plan sponsor where that money is going. The second obligation here is the gag clause prohibition attestation. So this is an annual requirement that on an annual basis, a attestation is uploaded to the CMS website that says that the contracts between the plan sponsor and their carriers, such as their TPA, their medical carrier, are free from gag clauses. And what a gag clause is just a legalese way of saying there are provisions in the contract that allow one of the parties to withhold data from the other. So again, the focus is transparency. So if one of the parties, specifically the TPA, is withholding information from the plan sponsor, obviously there is no transparency there. So this says that on an annual basis, this attestation needs to be uploaded to the CMS saying that the contract is free from gag clauses. Next item here is the RxDC reporting. So this is another annual requirement, a little bit heavier of a lift than the gag clause attestation. But in this reporting, there are several data files that need to be uploaded to CMS. Typically, the Rx carrier will handle the bulk of this as they are the ones that have most of the data. And the data files include information about the 50 most costly drugs, 50 most dispensed drugs, where basically, again, transparency, where are the costs going? Where is the premium going? There are some obligation for the plan sponsor or their medical carrier. We have seen medical carriers, for the most part, uploading the RxDC reporting files that the employer needs to upload as well. In some cases, the medical carrier does not upload those, in which case it would fall on the plan sponsor to take care of that. And then the last item here is this non-quantitative treatment limitations analysis, or NQTL analysis, and this is under the Mental Health Parity Act. And what this is, or what a non-quantitative treatment limitation is something like prior authorizations or visit limits. And what the Mental Health Parity Act does is it says that your mental health and substance use disorder benefits need to be in parity with your medical and surgical benefits. So thinking about a visit limit, if you have outpatient therapy benefit that has 5 visit limits, after 5 you can no longer go, or after 5 you have to pay some exorbitant cost. But on the medical surgical side, something that would be a comparable benefit to that has absolutely no visit limits. That's something that's likely not going to be in parity. So what this analysis is it says that the plan sponsor has completed the analysis and they have determined that their benefits are in parity. The next item here, so this is the one CAA 2021 slide that I did want to include because I did just want to touch on this. On an annual basis, there is a report to Congress that the Employee Benefit Security Administration releases. And what this is a 100-page document that basically outlines all of the audits that the EBSA has completed on the health plans throughout the reporting period. So typically it's a year, sometimes it can be a different interval. And out of that, they found a number of corrections that needed to be needed. So there were, as you can see here, they reviewed 39,000 group health plans. So it's an insane amount of plans. And they found, corrections that were affecting over 130,000 participants. So, what they're doing is they're looking at the health plans and they're essentially completing their own NQTL analysis. So because the obligation falls on the plan sponsor to have this analysis, oftentimes what they do is the DOL will reach out to the plan sponsor, they will request the completed analysis or information on the health plan, and then the employer has a specific number of days to release that information. Many plan sponsors are relying on their carriers pretty heavily for this analysis. So we have been discussing with carriers pretty much since this requirement came out and asking them how they are handling the analysis, are the plans in parity, those sorts of things. So while the carriers are confirming that the plans are in parity, many employers are still opting to do the analysis themselves as well, just kind of a proactive approach. What I will say is that there are a limited number of vendors that actually complete this analysis, and it is very expensive. So it can be cost prohibitive for so many plan sponsors. So because of that, it is a risk analysis that needs to be kind of determined by the plan sponsor to how much money they want to pay up front to complete the analysis, or do they want to take their chance and see if the DOL were to audit them and rely on their carrier. What I will say is the carriers that we talked to have all confirmed that their plans are in line with the Mental Health Parity Act. So with that, I'll jump into the CAA 2026. So we just looked at the CAA 2021. Now we're looking at the CAA 2026. Just for your own reference, annually, the federal government releases a Consolidated Appropriations Act. And what that is just a list of the things that the federal government is paying attention to, the new rules and new obligations. So that's why you may see a number of CAAs and then the comma in the year. But just so you're aware of that. So for the CAA 2026, this was signed in February. So this is something that I have discussed previously on prior webinars, as well as we've discussed this with a number of our clients, just to kind of keep everybody in the loop. But I did want to mention it again, as I do think it's important to kind of keep on your radar. Now, what I will say is that the bulk of these obligations are not effective until 2029. So there is time for plan sponsors to get everything in order that they need to get in order, but it is still just something to think about. So one of the obligations is that effective in 2029, PBMs and group health plans will be required to send semi-annual disclosures of a vast amount of their prescription drug costs, pricing, utilization, and compensation data. So similar to the obligations from the CAA 2021, again, focus is transparency. So one of the big things is that like I said, the disclosure obligation. So the following information generally must be disclosed by the plan sponsor. So there is a number of bullet points. I'm not going to spend that much time on this. Again, not effective until 2029. Just want to put it on folks' radar. So things like a list of all drugs for which claims were filed, the total out-of-pocket amount spent by plan participants and beneficiaries on each drug, the brand and generic information. So all of these things must be disclosed by the plan sponsor to their plan participants. One of the other things to note here is that PBMs must also provide plan sponsors with a summary document containing aggregate data for distribution to plan participants. So even though the obligation to is on the plan sponsor to provide the disclosure to the plan participant. The PBM is required to provide the necessary information. So there are still obligations on the PBM or the RX carrier's side. And just recognizing that typically a plan sponsor might not have all of this information. So it is a pretty heavy lift for plan sponsors. So there are, the PBM is on the hook for some of this. And then also just noting that the PBMs must remit 100% of all rebates, fees, discounts, and other remuneration related to drug utilization back to the plan sponsor every quarter. They have to maintain records. They need to make them available for audit. So like I said, there are a number of obligations that are going to fall on the PBM, but the biggest thing for the plan sponsor is to just be aware that they also have obligations to distribute disclosures to their plan participants. So just a few, action items, again, not effective until 2029. So likely if you join other webinars or if you are one of our clients, you will hear me talk about this at length until then, just because we always want to make sure that our clients are completely informed and know exactly what's coming down the pipeline. But just a couple things to get ahead of it. So you want to prepare to draft and review PBM contracts for compliance. So similar to these obligations that you had on the medical and TPA side from the CAA 2021, want to mimic those things for on the PBM side. Make sure that you are reviewing these contracts. You're making sure that the contracts do not include anything that would allow the PBMs to withhold information, those sorts of things. You want to make sure that you are reviewing the PBM disclosures at routine meetings. So, and I will likely talk about this later on. Again, something I harp on pretty heavily is the importance of having a fiduciary committee. So this is something, these disclosures are something that would come up during a fiduciary committee meeting. Are you reviewing those? Do these disclosures make sense? Are they in line with your understanding of the contractual obligations? You want to plan to make effective annual participant disclosures and then monitor the proposed regulations addressing PBMs. As always, you want to continue to monitor anything that's proposed. The government typically moves at a glacial pace, so something might be proposed today and doesn't get finalized until 6 or 7 months from now. So just kind of keeping an eye on those things. And then did also want to mention, and this is something that is effective sooner than 2029, is that the CAA 2026 modified the definition of covered service provider under the CAA 2021. So therefore, it expanded the scope of entities and vendors who are now required to comply with compensation disclosures to group health plans subject to ERISA, meaning that because of this expansion, it's no longer just the brokers or the consultants. And now there are obligations for different vendors, such as your PBM, to send these compensation disclosures. Currently, we are discussing with our clients' PBMs. I'm currently reaching out to them to understand where they are in this process. Are they providing these disclosures, or when the plan sponsor can expect them? There seems to be some differing opinions on when these disclosures are actually due. For some folks, they believe that the disclosures aren't due until the full effective date of the other CAA 2026 obligations. Others are reading this to mean that they are effective now and these disclosures should be sent. So that's why we're currently in the process reaching out to the PBMs to see where they're at in the process. If they come back and say that they are not sending these disclosures at this point, we're documenting those things for our clients, making sure that they have a record that there was outreach, that they attempted to receive these disclosures, and it was the PBM that turned around and said, we're not sending them to you. The next item here is the improving transparency into pharmacy benefit manager fee disclosure proposed rule. So it's a mouthful of a rule. And what this is this proposed rule came out shortly before the CAA 2026. And the obligations under the proposed rule are similar to those stated in the CAA 2026. The comment period for this rule has been extended. So it was originally the end of March. It was extended. There were supposed to be some finalizations in July. We're still waiting for additional information on this, but just at a high level for your reference, this would require PBMs and other covered service providers to provide disclosures to plan sponsors, outlining, among other things, direct and indirect compensation received from the health plan and other arrangements. So very similar to what we're seeing from the CAA 2026. These compensation disclosures are similar to what we saw from the CAA 2021. So it'll be interesting to see where this ends up and where the proposed rule goes, especially since so many of these obligations are very similar to what we already saw in the Consolidated Appropriations Act. So more to come on this. We're still currently tracking. Shortly before the presentation, I looked it up again to see if there was any more movement. So there are more to come, but just something to keep in mind. We are seeing different obligations on the PBM side. So hopefully we'll see some additional information, even if that information just says that the proposed rule is scrapped entirely and you can rely on the obligations under the Consolidated Appropriations Act. But we'll see. As soon as we know, we will release some kind of outreach to our clients and anyone else who is on our email list. Okay, with that, I will move into the New Jersey state Medicaid legislation. So this came out a couple weeks ago. I have a number of slides on this because it is something that is at the forefront of so many people's minds. So I will spend a decent amount of time here. So just for reference, this was recently enacted legislation which will tax certain employers if their employees or employees' dependents receive health coverage through the New Jersey State Medicaid program. So the stated goal of this is to raise funds and assist in funding the New Jersey Medicaid programs. And this is in light of recent federal cuts that we saw come out from the spending bill last year. And it's projected that this is going to raise around $145 million in revenue for the state. Whether it will remains to be seen, but that is the stated goal. At least that's what the state regulators are. That's their reasoning behind signing this. What I will say is this did seemingly come out of nowhere, at least from our perspective and the perspective of other compliance folks that I've talked to. It wasn't entirely on our radar as something that was going to be pushed through so quickly. So it will be interesting to see how this unfolds. But the most important thing, or the biggest question we always get, is how much is the fee and what do I really need to worry about? So the amount of the fee is based on the number of employees or employees' dependents who enroll in a New Jersey Medicaid program. So currently, it is broken down by employers with 50 to 249 employees or dependents who enroll. That would be $325 per employee or dependent. Those with 250 to 499 employees or dependents, that's $525 per employee or dependent. And then employers with 500 plus is $725 per employee or dependent. There are some potential additional penalties for late payments or non-compliance. So that is daunting. That is a pretty steep fee, or it can turn into a pretty steep fee depending on how your employees, whether they enroll. So just for reference, who actually qualifies for New Jersey State Medicaid? So New Jersey Family Care is New Jersey's publicly funded health insurance program, and this includes CHIP, Medicaid, and Medicaid expansion. And there are different eligibility qualifications. So for children under 19, they are eligible with higher incomes up to 355% of the federal poverty level. For adults age 19 to 64 with income up to 138% of the federal poverty level. And then for pregnant people with income up to 205% of the federal poverty level. So what this is saying is that from a financial perspective, these are the folks that may be eligible to receive either no cost or low cost healthcare through the state's Medicaid program. And then something to note is that the tax is applied to the employee as well as the employee's dependent. So even if the employee enrolls in the employer's health plan, if they do not enroll their dependent and that dependent goes and enrolls in the state Medicaid, the employer may still be subject to this tax. So are there exemptions? Yes. So there is some relief for employers. So the first is that those who are enrolled in Medicaid who have a developmental disability, intellectual disability, or a permanent physical disability, those employees will not be counted as enrolled in Medicaid and included in a tax against the employer. So if any of your employees enroll, but they have a documented disability, then they will be exempt. You will not be penalized for those folks. Additionally, as of July 1st, 2027, employees who have been employed by the employer for less than 90 days at the time the fee is assessed, part-time, per diem, temporary, and seasonal employees will also be exempt from being counted. So if you have part-time employees that are not offered health benefits just per your plan, and they go and they enroll in Medicaid, you will not be assessed a fee for those folks. If you are assessed a fee for any employee who will be excluded as of July 1st, 2027, prior to that, so say you get a letter in the mail August 15th, and those folks that they are taxing or you're being taxed for are part-time, you are entitled to a credit towards any liability owed or a refund in the following year for those people. Currently, the law does not contain exclusions for employers located outside of New Jersey. So if the employer has New Jersey-based employees or dependents enrolled in the state Medicaid program, you may still be liable for the fee. So we have a number of clients who are headquartered in a different state, but they have a few New Jersey employees. They may still be liable for the fee depending on whether the employees are enrolled in the state Medicaid program. And how are employees counted? So this is a question that I keep getting, and unfortunately, my answer is we don't know. So the legislative language is vague on how the state intends to count or identify the employees or the dependents covered by Medicaid. There are protections through different privacy laws such as HIPAA or New Jersey's Open Public Record Act that would prevent an employer from being able to review their employee population and see who is actually enrolled in Medicaid. So it makes it tricky for employers who are trying to assess what their risk may be. But it's anticipated that the state will likely match Medicaid enrollment records and employer unemployment insurance and or their wage reporting records to determine which employees or dependents are enrolled in Medicaid and working for that specific employer. We're waiting for additional guidance, which can be frustrating for employers. And folks are concerned about this. They're not really sure how they can address this. So many employers have no idea that their employees or their dependents are enrolled in Medicaid. So we are hoping that the additional guidance is available soon, but unfortunately, we're kind of in this waiting period right now. One other thing to note is there are explicit anti-retaliation provisions within the legislation that say that an employer is prohibited from using, considering, or relying upon whether an employee, the employee's dependents, or the job applicant is enrolled in a state Medicaid program when they are hiring or if there is a job advancement opportunity, meaning that you for just to put it in another way, if you are interviewing someone, you can't really ask them if they are enrolled in Medicaid, or if you know that information, you can't use that as a reason for not hiring that individual. So we believe that the reason for this specific anti-retaliation provision is that the state government anticipated that there may be some negative impact to employees as a result of this. So this is their attempt to kind of mitigate that risk. Employees, dependents, and job applicants have actual enforcement rights under the New Jersey Civil Rights Act and could potentially bring a claim against an employer if they were discriminated against on the basis of being enrolled in Medicaid. So some next steps. So despite the fact that we are waiting on significant additional guidance here, the law is technically effective as of its signing, so July 1st, 2026. Due to this, employers really should be considering their potential impacts and exposure that the legislation creates. They can ensure affordability within their plans, review the benefit offerings and plan costs to determine whether there are changes that can be made to entice employee enrollment if you have a number of employees who are not enrolling. While you can't necessarily confirm that they're not enrolling in favor of going on to the state Medicaid program, you can evaluate the plans and determine, are there other options that you can offer? You want to review your employee classifications to confirm which employees may fall into an exempt category. You can try to measure your risk the best you can and budget for potential liability. Again, unfortunately, we don't know how folks are going to be counted, so it is difficult to truly budget for this, but you can evaluate who is enrolling and perhaps base the potential liability on those who waive. And then you can also, for your open enrollment and your new hire enrollment processes, consider putting together some kind of enrollment waiver form. So if someone opts to waive coverage, maybe have them attest that they are not getting coverage through a state Medicaid program. There isn't anything in the statute that says that having these waiver forms is going to completely mitigate the risk of a penalty for an employer, but at least you have some kind of documentation. And maybe as we get additional guidance, there will be further information that it would allow an employer to receive some kind of relief if the employee said they weren't getting Medicaid and then ended up getting Medicaid. Again, having this waiver in place is not going to entirely mitigate the risk, but I wouldn't be the compliance person if I didn't say that documentation is extremely important, and I always err on the side of caution and have something in writing. Okay, with that, I'll move into a few legislative updates. No, I'm a little over the 30-minute mark, so I'll try to make this fast, but that was really something that I wanted to spend a lot of time on because it is brand new, it's important. We have so many clients who are concerned about it. The next item here is the changes to the New Jersey Family Leave Act. These were effective a few days ago, but did just want to mention for folks who may not be aware. So back in January, there was a piece of legislation that was signed that expanded the New Jersey Family Leave Act. And what the New Jersey Family Leave Act is, just for your reference, is it provides job protected leave for an employee to care for a family member, serious illness, or to take bonding leave after having a baby or adopting a baby or fostering a child, those sorts of things. It does not provide job protected leave for the individual's own medical illness or procedure or recovery from childbirth, something like that. It's purely for the family member. So specifically, this expansion expanded the definition of covered employers from employers with 30 or more employees worldwide to 15 or more employees. So it significantly expanded the employers who will be covered by this. For 2027, that is going to be reduced to 10 or more employees, and for 2028, that'll be reduced to 5. So eventually, we are going to see most employers with New Jersey employees falling into this covered employer category. What it also does is it reduces the number of months and number of hours an employee must work for the employer before they are eligible to take leave. They are also required to be restored to the position they held when the leave commenced, or to an equivalent position upon their return from leave. So this is new. Previously, it was just job protection. Now it adds this additional caveat. And then it also says that in cases in which employees is eligible for both earned sick leave and either temporary disability insurance or family leave insurance benefits, the employee may choose the order in which the benefits are taken. Previously, there was a set requirement. Now this is giving a little bit more flexibility. The legislation also discusses the family leave insurance and the temporary disability insurance, and there is speculation that there is now job protection attached to those two benefits. An employee who is taking leave while receiving the wage replacement benefits that the family leave insurance and the temporary disability insurance provide. So just for your reference, the New Jersey FLI and TDI benefits, they're just wage replacement. They are not leave benefits, whereas the FLA is a leave benefit. It's unclear whether this legislation is providing additional job protection through those benefits, which would expand the number of weeks an employee is able to take job protected leave significantly, or if they're just reiterating the already allowed New Jersey Family Leave Act job protection benefit. So something we're still waiting on additional clarification. Like I said, this was effective a few days ago, so I anticipate us getting more clarification around this shortly. My belief, maybe hope, is that they're just reiterating the job protection that's already afforded from the New Jersey Family Leave Act versus extending the number of weeks an employee can take job protection. Because, like I said, it would significantly impact the number of weeks. It would really expand that. I don't think that the legislature was intending on this being the case. Next item here, not going to spend a lot of time, but did just want to mention this is related to the independent dispute resolution process. And this was from the No Surprises Act. So you may have completely wiped it from your brain at this point. It was a number of years ago that the No Surprises Act was signed. We've been waiting almost 3 years for any kind of guidance on what this IDR process is going to look like. So we finally got some final rules. And what they say is that both providers and payers will now have this new obligation during the mandatory 30 business day open negotiation period that precedes its submission of disputes to the IDR process. So just high level, the IDR process is saying that if there is some kind of dispute related to the amount of the claim or related to the payment for the claim, there is now this dispute resolution process that's in place. This final rule also requires that providers initiate the open negotiation through the federal IDR portal. And I think that's really I don't want to say the most important part of this, but the part of it that kind of perks our ears up a little bit. So health plans and insurers must register in a new IDR registry to help providers correctly identify the payers. If the party uses a TPA or another organization to process disputes, the party does not need to sign up for the gateway, but they must ensure that their TPA or organization responsible for managing the dispute processing activities signs up. The portal doesn't exist yet. So even though this is something that we've started to look into, I'm currently doing a write-up on this and what this might mean for our clients. The portal itself doesn't exist at this time, so you can't go in and register yet, but it is just something to keep in mind, as it might be an obligation that you need to take care of. Next item here is the e-disclosure proposed rule. This is hot off the presses. We literally just got this information a couple hours ago, but I did want to include what we currently know in the presentation because I think it is important. It's something that we've been waiting on for a while. So the DOL's Employee Benefits Security Administration released proposed rules that would modernize how group health plans deliver required notices. This sets forth a new additional safe harbor for group health plan administrators to use electronic media such as email and intranet to furnish documents and information to participants and beneficiaries. If finalized, the rule would allow plan administrators who satisfy specified conditions to provide participants and beneficiaries with a notice that certain disclosures will be made available electronically on a website. So again, this is hot off the presses. We're not sure what's going to come of it. It's been speculated that the DOL was going to put something like this out for a while. They previously released e-disclosure rules for the retirement plan side. So like I mentioned earlier, retirement plan obligations always come first, and employee benefit plans or health plans slowly follows behind. So it will be interesting to see what comes of this. Again, this is another thing that I'm currently doing a write-up that we'll be posting on our website shortly as we start to learn more. The proposed rule is almost 100 pages long, so I didn't have time this morning ahead of this to really dive into it, but did just want to mention, kind of to put it on folks' radar, that we may start to see some additional relief for employers who are obligated to send out specific plan documents to their participants. The next item here is related to the high deductible health plan and HSA limits for 2027. Not really going to spend really much time here. I think it's kind of self-explanatory, but did just want to note that we did get the 2027 limits. As you can see, they have increased slightly. So the HSA maximum contribution for self-only went up to $4,500 and $9,000 for family. The minimum deductible for the high deductible health plan went up to $1,750 for self-only and $3,500 for family. And then the maximum out-of-pocket expense for a high deductible health plan is $8,700 and $17,400 for family. Really just wanted to note, as you know, we get the updated limits from the federal government throughout the year. So these are for 2027, and this is for plan years that are effective in 2027. Next item here is the PCORI fee. So this is due at the end of the month, but did just want to mention, just in case it is something that you're subject to and maybe you haven't looked into it or you aren't sure what you owe. So employers who sponsor self-insured group health plans, which include level funded plans and health reimbursement arrangements, are required to complete and file the Form 720 and pay the PCORI fee annually by July 31st. So for plan years that are ending on or after October 1st, 2024 and before October 1st, 2025, the fee is $3.47 per covered life. And for plans years that are ending on or after October 1st, 2025 and before October 1st, 2026, the fee is $3.84 per covered life. If you are a plan sponsor that has a self-insured group health plan as well as an HRA, the fee only is applied to the individual once. So if the person is enrolled in your health plan as well as the HRA, you don't need to count them twice. You just count them once. However, if the group health plan and the HRA have different plan years, then they would need to be counted twice and a different fee would be applicable. If you have a fully insured group health plan, typically the fully insured carrier is going to handle the calculation and paying the fee. I don't personally think it hurts to reach out to your carriers to confirm that they are addressing this and maybe maintaining any kind of documentation that they have available that states that they addressed this and paid it on your behalf. But for the most part, fully insured plans don't need to necessarily worry about handling the fee themselves. Next item here is the Form 5500. The Form 5500, as you likely know, has various due dates depending on your plan year. But for 1/1 plan years, the 5500 must be filed by the end of July, unless you file an extension, which is a Form 5558. And that would give you an additional 2.5 months to file the Form 5500. So employers who have at least 100 participants on their health and welfare benefit plan need to file the 5500. For employers who have a wrap plan document, they're able to file one Form 5500 and include all of the schedules, the Schedule A's for the plan. So those are the documents from the carrier that say how many participants were on the specific plan, what the premiums were, what benefits that plan covered, etc. Those are the schedules. If you have a wrap plan in place, you can file one 5500 with all of those schedules. If you do not have a wrap plan in place and you have multiple plans that have over 100 participants, you will need to file a separate 5500 with that schedule for each plan. So can be pretty burdensome. You'd be surprised how many employers do not have the necessary plan documents in place, but still file one 5500. So something to think about if you are close to that 100 participant mark and you don't have a wrap plan, might make sense for you to get one. I personally think that all employers should have a wrap plan document. I think it just streamlines their plan document and distribution obligations. But of course, that is, a decision that is dependent on how the employer wants to address it. The next item here is the MLR rebate. This is not something that you need to worry too much about yet, but because this might be, I believe this is the last quarterly compliance webinar prior to the due date of September 30th, did just want to mention. So this is something that's been in place for a number of years. And what this is at just high level is that certain insurers are obligated to send a rebate check to the plan sponsor, depending on how the premium and how the claims ran for the prior year. Insurers owing the rebates typically distribute them by September 30th following the reporting period. Although the insurance company sends the rebate to the employer as the policyholder, the employer is not always entitled to keep the entire amount. So if you have a plan that has employee contributions, then the percentage of the rebate that is equivalent to the employee contribution needs to be distributed back to the employee, to the participant. So employers can use the rebates either by reducing the participant's portion of the annual premium for all participants covered by any of the group health plan policies. They can reduce the participant portion of the premium for only the participants on the plan the rebates associated with. They can distribute back to the participants covered by the plan, such as through a check. You can also add additional plan benefits or plan enhancements utilizing the rebate check. So not anything that you need to worry about right this second, but did just want to put it on your radar as we slowly creep closer to September. Next item here, these are a lot of words, so I won't spend too much time just in the interest of time, is the Medicare Part D creditable coverage notice. This is due, just as a reminder, employers and plan sponsors need to distribute this notice to Medicare participants and beneficiaries annually prior to October 15th. And what this notice says is that the prescription drug coverage is considered either creditable or non-creditable compared to the Part D prescription coverage through Medicare. Employers are not obligated to have creditable prescription drug coverage, something that like to mention, is I think that, many employers, when they see that their coverage is non-creditable, they are concerned by this. You're not required to have creditable coverage. Your only obligation is to send this notice to your plan participants, so that they're aware. Because if the coverage through the employer plan is non-creditable, they have the obligation to then either enroll in a different health plan that is considered creditable through the employer, or enroll in Part D coverage directly through Medicare. So for employers offering prescription drug coverage through their group health plan, there are two ways to determine this. There is the revised simplified determination method, which is effective for 2027, or there is the actuarial determination method. Actuarial determination method obviously means you need to engage with an actuary to complete the analysis. A few months ago, we received final rules. So the first one discuss the simplified determination method, and saying that the plan sponsors are no longer able to utilize the old simplified determination method. They now are able to use the revised simplified determination method. If you haven't been paying attention to this, you're thinking, why does this matter? But for folks that were aware of this or tracking how they needed to complete this calculation, uh, previously it was believed that CMS was going to do away with all simplified determination methods for determining whether the coverage is creditable, and exclusively rely on the actuarial method, which would have been a potential administrative headache for a lot of employers who do not typically engage with actuaries. So this is a big deal. There is still some relief through that revised simplified determination method. The other thing that came out of this final rule is that account-based plans such as health reimbursement arrangements, FSAs, and health savings accounts are excluded from the notice of creditable coverage requirements. So previously, these account-based plans needed to be factored into this creditable coverage determination. The government, recognizing that it's difficult for employers to make those comparisons and do those analyses, they're now excluding them. Despite the change, plan sponsors are still required to evaluate whether their prescription drug plan is creditable. But with this exclusion, the risk of individuals receiving contradictory notices is mitigated. So that was one of the other concerns that the government had, was that the prescription drug plan itself might be creditable, but the HRA, based on the analysis, is non-creditable. So how is that going to impact the participant? Do they need to enroll in Medicare? What do they actually need to do? So this mitigates this risk and just says that if you get a creditable coverage notice from the health plan, then you have creditable coverage across the board, regardless of how the HRA plays out. Just in the interest of time, not really going to spend too much time here, but these are just always, I like to give some reminders. So, employers are required to send the SPDs. If you are not putting those together, or you're not receiving them from your carrier, want to make sure that you are. You have annual notice obligations. Annual non-discrimination testing. This is something that comes up with a lot of our clients. We typically suggest testing mid-plan year. That way you have time to make necessary corrections if there are any. This is something that we do for our clients. And then finally, HIPAA privacy and security. HIPAA breaches and data breaches are on the forefront of everybody's mind. So want to make sure that any of your policies and procedures are updated, making sure that you have those policies. If you're obligated to do HIPAA training, making sure that you're doing that on an annual basis. Next, we have some Secure Act items. This is something that I talk about, again, often. I'm not really going to spend too much time here, but just at a high level, Secure 2.0 impacts retirement plans, specifically 401ks and 403b plans. And the reason for the act is that recognizing that we are in a bit of a retirement crisis, where a number of folks who are reaching retirement age do not have enough saved. The federal government enacted the Secure 2.0, which added additional flexibilities in an effort to make it so folks are able to save more towards retirement. The first thing here is related to the Roth catch-up contributions. This was effective at the beginning of the year, and it updated the salary threshold for those who are eligible to have catch-up contributions for the employer's 401k or 403b plan. The reason I kept this in, the reason I wanted to talk about this is that even though it was effective at the beginning of the year, want to make sure that any of the changes that you're making from as a result of the Secure 2.0, either whether they're mandatory changes or there are a number of optional changes that came out of the Secure 2.0. So it's really up to the plan sponsor and the record keeper whether they want to implement them. Want to make sure that you are updating your plan documents prior to the end of the year. So we are almost in August. We're closely, very, very closely getting towards the end of the year. So want to make sure that any changes that you're making, you're updating your plan documents. If you need to distribute this information to plan participants, you're doing so. Our retirement team works with our clients and their record keepers to make sure that these updates are being made. So really just wanted to mention that, even though there isn't necessarily anything that you need to do right now, you likely made those changes in January, but did just want to, as always, mention documentation. So last thing here, I talk a lot about fiduciary process and your obligations and what you need to do as a plan sponsor. The biggest thing is you want to establish some kind of fiduciary committee. Do you have a charter in place? Do you have a process for collecting meeting minutes? Are you reviewing your plan documents as a committee? Have you established the roles that each person on the committee must adhere to, what they must do? Or are you just receiving the contracts and taking them at face value and signing them and putting them away and never looking at it again? We're seeing all of these obligations, these transparency obligations coming out. So it's crucial for the plan sponsor, who actually is the fiduciary, to make sure that they are reviewing everything they're receiving and documenting it accordingly. Are you analyzing the agreements and making sure that they're in line with your understanding? And then is your fiduciary committee actually executing the strategy that you came up with? There's a lot that goes into having an efficient fiduciary process. This is something that we talk to our clients about a lot. We discuss, some of the steps that they can take to ensure that they are compliant and ensure that they are executing their obligations correctly. But something that I always like to mention it. So many of these obligations are ones that fall on the plan sponsor as the fiduciary. So I want to make sure that you are documenting everything and you are keeping track of your obligations. So with that, that is the end. And that was a bit of a crash course and a lot of information. But if there are any questions, I can address them now. Of course, if you don't have any questions now, but you think about it and you have questions later, feel free to reach out to me directly, or you can reach out to another member of your account team and they can funnel the question over to me. But right now, it doesn't look like we have any questions. A recorded version of this will be available. But again, thanks so much for joining. I hope you have a great rest of your week.